From its first Chief Justice, John Jay, to its current one, John Roberts, the court continues to make decisions that impact the lives of everyday Americans, taking on only a limited amount of cases per term compared to the number of those requested of them.
8,000 ask us each year to hear the case. That means about 150 a week. 150 what? 150 requests to hear the case. Well, here they are for this week.
I think undoubtedly to my mind, the most, what should I say, onerous and for the most part uninteresting part of the job is ruling on all of the cert petitions that come to the court. And they've increased enormously in the time that I've been here.
It's an interesting process. We don't try to just, look at the cases that we think are wrong. We don't look at the cases that we think have a lot at stake. Our main job is to try to make sure federal law is uniform across the country.
All the cases are hard. The only reason we take them, as some of my colleagues may tell you, is that other courts are in disagreement most of the time. And that means that other judges and other actors in the legal system have come to differing conclusions. Every case is that way.
Most people think they have a right to come to the court. For the most part, you don't. Not this court. Maybe the Court of Appeals, you normally do. Maybe the state courts of appeal and final, the courts that don't have discretionary jurisdiction, the courts of last resort, maybe they have a right to go to those. But here, most of our jurisdiction is discretionary. In other words, we decide if you come.
You can tell if there's a case that's on a particular hot button issue that people are going to give it a lot of attention. But I have to say that doesn't enter into our process of deciding. A lot of our docket is very mundane. You go through the year and say we're deciding 90 cases. Probably a half dozen are ones that are going to make it to the front page of the newspaper. All the others, bankruptcy tax case and Federal Arbitration Act case, a pension plan case. Those are actually a big part of our docket, all vitally important, but not anything that's going to attract any interest.
Even a case on a subject that you think of as kind of boring can turn out to be enormously challenging at the end of the day. It could be anything. So I don't think subject matter determines the extent of your interest in it. It's the challenge of solving this particular question of law and making it work. It could be on any subject.
Each one gets a vote, just like anything else, on what cases we should hear, but it only takes 4 votes to grant cert and decide that we're going to hear a case. The court used to have a lot more mandatory jurisdiction, cases they had to hear, and when they got Congress to pass a law saying that we didn't have to hear all the cases, it wasn't mandatory jurisdiction, kind of the deal we made with the Hill was that you didn't need 5 votes to hear a case, 4 would be enough.
These are the cases in Justice Stephen Breyer's office that were granted and heard in the courtroom. Behind the scenes, each justice has their own suite of offices. Here they work with a staff of 4 law clerks and several office assistants. But it is within their own chambers where their personalities and work habits come through.
I like to be in a quiet place. I like to have my law clerks close at hand. In my regular chambers, all of the law clerks were inside chambers. Now I have 2 that are in that office and 2 down the hall. But I like a quiet place. I'm glad to be overlooking a courtyard and not the front of the building, so I'm not disturbed by demonstrators. This desk is made here at the court. All of the chambers have similar desks. The variation in these chambers is that I have put a granite top on the desk.
I was very lucky to have this office. It was Harry Blackman's office. He was my predecessor here. It's a lovely office, and I think the year before Ruth Ginsburg was appointed, and everybody moved because you obtain offices by seniority, really, and I was the most junior. But then when I was appointed, no one wanted to move. I said, that's fine with me. I was lucky.
It is this view from Justice Breyer's chambers that provides a window into the past of the Supreme Court. Meeting in the basement of the Capitol for the majority of their time between 1810 and 1860, John Marshall oversaw the court from here during his tenure. And later, Roger Taney ruled over the chamber as well, until the court moved upstairs into a space vacated by the Senate, where they would meet until 1935. But with very little space available in the building for justices to do their work, and with even less for attorneys to find a place to prepare for oral argument, one Chief Justice determined it was time the court have a building of its own.
I don't think it's an understatement to say that this building would not be here if it hadn't been for the persistence of Chief Justice Taft.
Taft had in mind that the court needed to have a building of its own. He believed that when he was president, and when he became Chief Justice, it became almost an obsession. There was some opposition in Congress, but ultimately Taft began to chair the committee that was to choose the architect. Gilbert was very much the first choice that Taft had in mind. Cass Gilbert was one of the best-known architects of his time, and so it was the perfect match of architect and employer. Their idea was to have a building that would comport to Jefferson's concepts and that would look right next to the Capitol building, but still stand on its own. The appropriation that Taft asked for was a little bit less than $10 million. During the Great Depression, there was actually a deflation, and so they were able to build the building and furnish it and still turn $100,000 back to the Treasury of the United States. So it came in under budget. Maybe the only government building in history that came in under budget.
Gilbert thought he had done such a great job that the U.S. Capitol should be moved so that people would have a better view of the court. That was his view. And I think he did create a beautiful building. But there's no way the Capitol's going to be moved to provide a better view.
Gilbert worked in what is essentially a sort of French Beaux-Arts classicism. He was very serious in his intention to create a house, and a symbolic house, for the third branch of government that expressed the seriousness of what we were doing, the authority with which the third branch should be invested, and an authority really to work for what was right.
Supreme Court justices are not shy, and some of the justices felt that the new building was too grand, was too grandiose. Chief Justice Stone is alleged to have said that the justices were like 9 black beetles in the temple of Karnak, and that maybe they should ride in each morning on elephants.
Setting a record with over 75 million pounds of marble used in its construction, when it opened in 1935, 7 of the 9 sitting justices refused to move into their chambers in the new Supreme Court building.
Van Deventer, who was one of the justices at the time who did a lot of work on it, didn't want to leave the former chambers, which was in the basement of the Senate. And he said, if we leave these offices in the Senate, no one will ever hear of us again. Well, he was wrong. Brandeis said he wouldn't come in here. And the reason Justice Brandeis wouldn't come is he said this building is so elaborate it'll go to their heads. Maybe he was right. But it's become over time a symbol of the court system, the third branch of government, and the need for stability, a rule of law, which is what America stands for.
The interesting
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh, yea, oh, yea, oh, yea. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
One of the amazing things about that courtroom, despite its splendor, is the intimacy of it. On the one hand, it's not that big a room, but the real intimacy comes in the relationship between the lawyer who was arguing at the podium and the court that he's arguing to. And if you stop to think of it when you go in there, you will see that if one of us leaned over the bench as far as we could lean, and the lawyer arguing at the podium leaned toward us, we could almost shake hands. And that is a very important thing, because it means that when the arguments take place, you are physically and psychologically close enough to each other so that there is a possibility for real engagement. We're just not a bunch of people talking in microphones with a big space between us. So the happy paradox of that room is that it is a grand room in which a very intimate process takes place. And it is the kernel of a very grand building which has very intimate results for every American.
The aura of the place is always present. This is the chamber where Brown versus Board of Education was decided. This is the chamber in which the big steel seizure case was decided. The most important decision in our history in defining presidential power was decided in that room by human beings sitting on that bench after having listened to argument by other human beings.
Most cases have an hour per case, a half hour per side. When you tell that to people, they think, is that all? And when you look at some of the other common law jurisdictions, they have a lot more. But a lot of the argument's been laid out in writing. Lawyers are not expected, and even if they expect to, they're not going to have the chance to get up and give a speech. A lot of the argument, most of the argument, is devoted to justices' questions.
It's very intense. That's what it's really like. You're seated right next to the podium, so you really just stand up and slide over a few inches. The first thing you have to say under court etiquette is, Mr. Chief Justice,
and may it please the court. The 10th Circuit in this case correctly held that Stone could not share in the award given by the jury unless he
and then
was
you're off. And then you have a few sentences usually that you have chosen to deliver the court, but you will start getting questions, usually within the first minute or two.
Each of the justices has their own unique style about questioning. We have some people who like, the rapid fire style, others who like to spin out long hypotheticals.
I don't want legalism, I just want the conclusion. A minute has passed before he says yes. Has that changed everything and it becomes lawful?
Would you explain again why it was irrelevant whether the gun was operable or not?
What if in your hypo the government came along and said, in order to run your hospital, you've got to disclose certain facts. Otherwise, we're going to shut it down.
It's the first time we learn what our colleagues think about a case. We don't sit down before argument and say, this is what we think, or this is how I view the case. We come to it cold as far as knowing what everybody thinks. And so through the questioning, we're learning for the first time what the other justices view, how they view the case. And that can alter how you view it right on the spot. And if they're raising questions about an issue that you hadn't thought was important, you can start looking into that issue during the questioning a little bit. So it's a very dynamic and very exciting part of the job.
There are 9 people up there, and I'm with them, and we're talking. This is a conversation. And I have no awareness of the courtroom, the people in the courtroom, any physical movements that may be going on. It's really quite remarkable.
My philosophy is to ask questions when I think the answer might give me a little help in deciding the case. I don't view the participation of a justice as an opportunity for the justice to advocate one point of view. I think rather the questioning should be designed to help understand what the arguments on both sides are in order to enable the justice to reach a decision.
To sit on the Supreme Court and listen to the questions of your colleagues is somewhat humbling. The moment that I sat down and was able to look out and see all of the people in the audience, that's probably the moment I will most intensely remember. because there were lawyers who I've known for years sitting at the table in front of us, ready to argue. But then watching the intensity of everyone's face, and I'd forgotten how much people believe and know that they're affected by the court's decisions. Every question I ask has a purpose. It has some importance to something that is troubling me or that I'm curious about.
As an attorney, I welcomed questions from the bench. I know that some lawyers regard questions as an interruption in an eloquent speech that they are prepared to make. But an advocate wants to know what's on the judge's mind, so she will welcome questions as a way of satisfying the judge on a matter that the judge might not resolve as well without counsel's response.
It's all about just fielding those questions and using the time strategically so that you respond to the questions. It's essential to answer the questions. You can't persuade a justice if you don't answer what they have asked. They're very demanding, as they should be. That's their job. It's a very challenging exercise.
Is 2% a critical mass, Ms. Mahoney?
I don't think so, Your Honor.
Okay. 4%?
No, Your Honor.
You have to pick some number, don't you?
Well, actually, what
like 8 is 8%?
Your Honor,
Now, does it stop being a quota because it's somewhere between 8 and 12, but it is a quota if it's 10? A lot of people have the impression that it's just a dog and pony show. What can somebody tell me in half an hour that's going to make a difference? And the answer is that it is probably quite rare, although not unheard of, that oral argument will change my mind. But it is quite common that I go in with my mind not made up. I mean, a lot of these cases are very close, and you go in on the knife's edge. Persuasive counsel can make the difference.
I once had an argument where I think they asked 56 questions in 30 minutes. So it's a lot of questions. And yes, they interrupt each other even.
It had been my practice on the Court of Appeals to try to wait for sort of the end of the lawyer's paragraph before interrupting with a question. And here I learned if you do that, or even if you, in a hot case, if you wait till the end of a sentence, you will never get a question in. You have to interrupt to make your voice heard.
The argument is for us to say, well, yeah, we've read your brief, we know what you think of the case, but here are the questions that inspired in us. You know, here are the concerns we have, or here are the uncertainties that you left open, and use oral argument in order to do that.
I guess I view oral argument a little bit differently. I think it's an opportunity for the advocate, the lawyers, to fill in the blanks. I think it's hard to have a conversation when nobody's listening, when you can't complete sentences or answers. Perhaps that's a Southern thing, I don't know. But I think you should allow people to complete their answers and their thought and to continue their conversation. I find that coherence that you get from a conversation far more helpful than the rapid fire questions. I mean, I don't see how you can learn a whole lot when there are 50 questions and a half in an hour.
One of the bad signs of an oral argument is when the questions stop. It means that, you know, you've either not persuaded them or they figured it out already and there's nothing more you can add.
A white light will go on when you have 5 minutes remaining. And when your time has expired, a red light goes on. When the red light goes on, you are supposed to stop.
It's an exciting part of the process. I'm going to learn what my colleagues think about a case that I've been studying for a long time, for the very first time. I'm going to hear what the lawyers have to say. So it's an exciting day.
The Supreme Court, rich with traditions, is also a very human institution. In a private room reserved for use by the justices, a newer custom takes place following oral arguments, one encouraged by its first female justice.
It is wonderful room, very well furnished. But the food is not exactly haute cuisine. It comes from the public cafeteria. The justices eat same things that any visitor to the court might choose for lunch. You will be surprised by the high level of collegiality here. Justice Scalia once commented that in his early years on this court, there was no justice with whom he disagreed more often than Justice Brennan. And yet, Justice Scalia considered Justice Brennan his best friend on the court at that time, and he thought the feeling was reciprocated.
This is a tradition, eating lunch together, that was really pushed by Justice O'Connor when she was on the court, and it stuck.
Justice O'Connor insisted that we have lunch every day when we were sitting. Now, Clarence, you should come to lunch. And she was really sweet, but very persistent. And I came to lunch. It was one of the best things I did. It is hard to be angry or bitter at someone and break bread and look them in the eye. It is a fun lunch. Very little work is done there. It's just 9 people, 8 people, whoever shows up, having a wonderful lunch together. It is wonderful.
I try not to miss a post-argument lunch because you never know what my colleagues will be talking about.
Usually on an argument day, most of the justices are there in our dining room, and it is the rule there that we don't talk about the cases. My colleagues who go to the opera will talk about the opera. Some of us will talk about the baseball game or the golf tournament. Somebody will talk about a good movie they've seen or a good book they've read. What's something particularly interesting their family's doing, the kind of things everybody would talk about at lunch with colleagues.
Off the main justice's dining room is a smaller dining room for smaller functions known as the John Marshall dining room. And that's due to a sculpture that was placed there in the mid-1970s of John Marshall. Chief Justice Warren Burger decided that he wanted to make that the theme of the room, and so the court had been donated a portrait of William Marbury, and Marbury was the famous litigant in the case of Marbury versus Madison back in 1803. Chief Justice Burger said, we need to get a companion portrait for that, and so the great litigants Marbury versus Madison are on the wall, literally, of this small dining room.
Marbury and Madison is probably the most famous case this court ever decided. The idea of judicial review for constitutionality, I think, is implicit in the constitutional document. But John Marshall made it explicit in the great case of Marbury against Madison.
In all of the Supreme Court's history, there is no one case that says as much to a justice about what it is like to be a justice. Because Marbury versus Madison is the embodiment of judicial review. There's no quotation in all of the history of Supreme Court writing that justices more prefer to repeat than the phrase which says, it is emphatically the power and the duty of the judiciary to say what the law is. That's a quote from John Marshall in Marbury versus Madison.
We call him the Great Chief. He really was the first person to take the job seriously. He really established the court in a prominent position as one of the 3 co-equal branches of government. The chief's responsibility is to preside at oral arguments and also to preside at the conference where the justices vote on and decide the cases. That means I get to initiate the discussion and have some responsibility to make sure that all the issues are adequately aired at conference.
There is a change when the new Chief Justice is presiding at conference. Each Chief Justice has his own method of handling and presiding at the conference, and the present Chief Justice is doing an excellent job. It has some virtues that the others didn't have, but that's pretty much follows the tradition that's been followed for many years.
On the one hand, there's not much
the Chief Justice can do. His 8 associate justices have a lifetime job. They have a duty to uphold the Constitution. He can't fire them. He's got to get along with them. We have traditions which will outlast any Chief Justice. And so the Chief Justice comes to a court where there are these elements of stability and permanence and protection. And we have our tradition, and we have our oath. On the other hand, the Chief Justice who presides over our conference and steers us through the mechanics of hearing the cases and calendars, by his personality and his warmth and his decisiveness and his understanding of the law and of the institution of his colleagues, can do a great deal to set the tone.
When I got here, my colleagues were very helpful in filling me in on how things worked, often in contradictory ways, but you do get some sense about what's expected in the process. And then you go in and do it and hold your breath and hope they all don't say at once, well, what are you talking about? Why are you doing that? And the real key is that my 8 colleagues were extraordinarily helpful in making me feel very comfortable. I mean, imagine, it's not just that I was coming in as chief and the youngest among the bunch, and in many respects the least experienced as a judge, but they had been together for 11 years without any change. And you can easily imagine that that would be difficult. But every one of them, I think, went out of their way to make me feel comfortable in the process, for which I've always been very appreciative.
In the most private and perhaps important place inside the Supreme Court, 9 justices, and only them, meet together around a table in the justices' conference room. They discuss the cases heard at oral argument and begin the process of reaching a decision of the court.
We sit at the conference table in the same places every day. I sit at one end, and then it wraps around the table in order of seniority.
I can still remember the first time I set foot in that room and those doors closed. My goodness, it's pretty daunting the first few times because that's where the actual work and the decision making takes place.
We don't have any observers in the conference room. No one can enter the room who is not a justice, no secretary, no law clerk, not even a message bearer.
I have to be professional and accurate and fair, and each of my colleagues feels the same way. So there's a little tension and excitement in the room, but we love it. We're lawyers. We're designed to do that. The job is no good if you can't argue.
I initiate the discussion. For an argued case, I'll say this case is about this, the arguments are so-and-so, and I think we should reverse or affirm, and here's why. Sometimes in an easy case, it will take a minute. In a hard case, it can take a lot longer.
Now, one of the best rules, and I think it's true for any group, the rule of that conference is no one speaks twice until everyone has spoken once. Of course, I was most junior, so it helped me, but I think it's a very good rule. It produces a very good feeling because everyone feels that he's been heard.
It's great to go first because you can tell the rest in a persuasive statement what you think of the case. But when you're on the end of that queue, you do have a certain advantage. That is, you know what the others think.
It is not really an exercise in persuading each other. It's an exercise in stating your views, and the rest of us take notes, and that's its function. You take notes so that if you get assigned the opinion, you know how to write it in a way that will get at least 4 other votes besides your own.
I was the most junior member of this court for 11 years. And it was always, when we had our conferences, since no one else was in the room, I had the special job of opening the door in case somebody knocked. Somebody knocked, usually somebody forgot a paper. Once they had coffee for Justice Scalia. So I said, well, I've been doing this for 10 years. And he said, and I said, I think I've gotten pretty good at it. He said, well, I'm not sure. So we get on very well. I mean, the 9 of us get on very well.
I mean, who would want to be part of an institution where everybody dislikes each other? You know, I think it's actually one of the great things about the court right now is that even when people disagree, and sometimes disagree sharply, there are important questions, hard questions that people have strong views on, but that they can understand that everybody is trying to do the best they can, and everybody's working really hard, and everybody cares a lot about the law and about this country as well.
I just finished my 18th term, and I still haven't heard the first unkind word in that room. And you think what we've decided: life and death, abortion, execution, war and peace, financial ruin, government relationship with citizens, you name it, we've decided it.
Those discussions lead the justice to conclude tentatively to affirm or reverse in the particular case. Now, that vote is not cast in concrete. You are not walking on wet concrete yet. You can change your mind.
And it's not just win or lose, reverse or affirm, it's what rationale you use, what principle you use to teach something. And if the case is close, 5-4, and let's say you're on the side that prevailed, the majority, there are not a lot of high fives and back slaps, and there's a moment of quiet, a moment of respect.
My most important responsibility is the responsibility for assigning opinions once the votes are in. If I'm in the majority, I get to determine who will write the opinion in that case. And that's a very important responsibility, because you want to make sure that the assignment is given to the justice whose view commands the most support on the court. You want to make sure the work gets done on time, so if someone's a little slower than others, make sure that person gets assignments, heavy assignments earlier on. Some cases are more interesting than others. You want to make sure those are fairly distributed. Some cases are harder than others. You want to make sure that's fairly distributed. We get all sorts of different issues. You want to make sure each justice has a nice mix. You don't want one justice just doing criminal cases or something like that. So a lot of factors go into that decision, and it's a very important part of it.
When we get through, we sometimes have coffee sent in and maybe eat a sweet roll or cookie or something.
As opinion writing assignments are handed out at the end of conference, a room exists upstairs in the Supreme Court which helps the justices and their staffs consult precedent through the words written in the countless legal volumes housed here. A room filled with not only books, but the symbolism of the great lawgivers, and admired by those few who enter into its mahogany grandeur.
If they want to see the most beautiful room in Washington, they ought to go up to the library on the 3rd floor that nobody hardly sees today. That's not so much Roman classicism as Renaissance classicism, but it is just a breathtakingly beautiful room.
The library is probably one of the most special places in the building. The lunettes, the archways in the library, represent science, law, industry. There are shields that are directly above the archways, and those represents various printer symbols. When I was clerking, I spent a lot of time in the library, and it was a gorgeous library. We wouldn't go there to read Supreme Court cases because those would be in our own chambers, but when looking for secondary materials of different kinds, we would go to the library and we would work with the librarians. It was a wonderful place to work. It was also a quiet place to work.
The library is one of the special rooms in the building. Unfortunately, it doesn't get used as much as it was when the building was first opened, and that goes back to the way the court has changed the way it does things. When the court first moved into the building in 1935, they would literally call the docket each day in court. So you didn't know which case was necessarily going to be argued that day. You had an idea, but a lot of attorneys had to be on site because if their case came up, they needed to go down and be ready to argue it. So that's why you have the lawyer's lounge, which is a place for them to stay while they're waiting to find out which cases are going to be argued. And it's why you have this magnificent reading room here in the library. And this space is reserved for the use of the members of the bar and the court staff only.
There have been a few times when I had to use material from so many cases that we occupied 2 or 3 of those tables, leaving the books out so that the law clerks and I could go up there and sit up in the reading room and actually refer to all those passages in the preparation of an opinion.
With precedents and cases researched, in quiet chambers below this library, justices go about the process of writing the opinions, both majority and dissenting, that eventually make their way to the public as the final decisions of the court.
It's an ongoing process. You write a first draft. You figure out, well, I need to know a little bit more about how this case fits in. You go back and read the case. You're always going back and looking at the briefs, always bringing the law clerks in and bouncing ideas off of them. You know, what's wrong with it? It's sort of a continuation of the oral argument process.
Deciding your view of the case itself is terribly challenging. Some of the issues are really tough. Some are not. Some are clear-cut. But some are enormously challenging. And some cause you to want to wait yourself until you see other views expressed before being firm in your own view. And it is a help to see it in writing. And it's a help when you have to write, to have to put it down in words rather than just think it through. It's a real challenge.
We have to convince ourselves. When I sit down and write an opinion, the first thing I do is convince myself. There's a lot of stuff goes in the wastebasket. And then you have to convince others. So again, this court reminds you of the fact that you have this job to do.
So when you try to write something out, you sometimes learn things about the case that you didn't fully appreciate or understand before. And there have been more than one case in which I have changed my views when I was writing the opinion.
As I have often put it, I do not enjoy writing, I enjoy having written. I find writing a very difficult process. I sweat over it. I write, I rewrite, I rewrite again. I mean, before the opinion goes out, the law clerk will say, it's going out this afternoon, you want to read it one last time? I say, yeah, let me read it one last time. And I guarantee you every time I read it, I will change something else. So finally it has to be wrested from my grasp and sent down to the printer.
I usually have to write 2 or 3 drafts pretty much from scratch before I'm reasonably satisfied that we're going somewhere, and then we edit them back and forth. And after they're edited back and forth, I circulate it, and I hope 4 other judges join. If 4 other judges join, I have the court.
We realize that one of us is going to have to write out a decision which teaches and gives reasons for what we do. The point of writing an opinion is to command some allegiance to the result. And we have no army, we have no budget, we do not have press conferences, and we don't give speeches saying how wonderful my dissent was or how bad the majority. We don't do that. We're judged by what we write.
I would like my opinions to be as clear as possible. I would like people to pick them up and understand them. I would like them to be as thoughtful as possible. I would like to write the kind of opinions which really do address the competing arguments, don't try to sweep competing arguments under the rug, but try to address them fairly and forthrightly.
Now, once the person assigned to write for the majority opinion circulates an opinion draft, then the other 8 have a chance to weigh in. And normally they start acting within a day or 2. They'll read it and say, "Dear Sandra, I join." Or, "Dear Sandra, I'll wait for the dissent." Or, "Dear Sandra, I want to give a little more thought to this before I act." Or, dear Sandra, if you will change A, B, C, and D to E, F, G, and H, I would be able to join. I mean, it's something like that that happens. Now, if there is a dissenting opinion to be written, often people will wait and look at the dissent before casting their vote. Now, once the dissent circulates, it could be so powerful that it causes someone who tentatively had been with the majority to change their view to some extent. So all of this, the details are worked out not around the conference table. It's in the writing of the opinions that the persuasion takes place.
Let's say I would go the same direction, but I'd go 80 yards. But the majority only wants to go 60, and 60 would decide this case too. So I would write the opinion to go 60 and not say anything about I would also go the other 20 yards. Now, if I were writing a concurrence or dissent on my own, I would write the opinion in a way reflects that I would go 80. So we're going the same way. I could not write an opinion that went in a direction that was different from what I actually thought we should go.
The dissents here are very, they are rigorous and they don't pull punches. So I think it ultimately improves the quality of the majority opinion, but it's something you have to anticipate.
Dissents are more fun to write. I got to say that, because when you have the dissent, it's yours. You say what you want, and if somebody doesn't want to join it, who cares? You don't want to join my dissent? Fine, it's my dissent. This is what I want to say. When you're writing a majority, you do not have that luxury. You have to, craft it in a way that at least 4 other people can jump on, and actually you try to craft it in a way that as many people as possible will jump on, which means accepting some suggestions, stylistic and otherwise, that really you don't think is the best, but are the best, but nonetheless, in order to get everybody on board, you take them.
If you're just starting out and someone says, I'd like you to change this or that, you're going to be very receptive. When you've got 8 votes and the 9th one comes in saying change this or that, you often say, well, not quite go fly a kite, but the 5th vote is a more critical one. You're more susceptible to making changes than the 9th vote.
The job is to get to it. We're not here in an academy to spin out theories. We're not here producing works that are never going to see the light of day. We're here to decide things. The job is to decide. We decide.
God save the United States and this honorable court.
Justice Alito has the opinion of the court this morning in case 08289, Horn versus Flores.
This is our moment. The press grab the copies of the opinions and go rushing through. And the guy from Reuters is always the most pushy to get through because he wants to get on the wire service, so you better get out of his way. But the rest of us then go and either dictate or write. The remaining decisions will be issued on Monday. The Supreme Court Public Information Office simply says, here's the material, make of it what you will. But we will make sure you have the material. And that's an enormously invaluable function. And it's also very nice not to have the sense that somebody's trying to spin you.
I personally do go up and want to hear the opinion announced from the bench. I like the pageantry of that. I like to hear the justice himself or herself announce what's in the opinion. Then I race down the stairs to the court press area where we all have our laptops set up now, and I write a first version of that story so that it can get on our internet site. Readers really want to know as soon as possible what the court ruled and potentially what that might mean.
A lot of people say, well, it's a very secretive institution. No, it isn't. It's an institution that virtually does most of its work in the open. And as they like to say, the work comes in the front door and goes out the front door.
You are just a few steps away from the courtroom.
Near the courtroom are 2 rooms used by the justices to occasionally speak to the public as well. From Thurgood Marshall's retirement announcement to events with other justices over time, one can get a glimpse into the workings of the court and life here. But it is the private view of the ornately decorated East and West conference rooms and their portraits of past Chief Justices that helps one understand the history of the court.
In the East Conference Room, we have the first 8 Chief Justices' portraits. So you can go in there and you can talk about the portrait of John Jay, the first Chief Justice, and how he came to the court appointed by George Washington. And then he gets elected to be governor of New York and decides that that's a better job than being Chief Justice of the United States. So he resigns and becomes governor of New York. And then you have a beautiful portrait of John Marshall by Rembrandt Peale. Here's the great Chief Justice himself in a grand portrait, very similar to the one of George Washington in the Capitol building. And there's a chance to talk about John Marshall, to let people know his story. And that carries through over into the West Conference Room with the more modern justices, where in fact you have the 2 instrumental justices in this building. William Howard Taft on one wall and Charles Evans Hughes above the fireplace, looking at each other through time.
I like to go sometimes on a quiet night to the conference rooms because the portraits on the walls, 8 in one room and 8 in the other, are all my predecessors as Chief Justice. To some extent, you look up at them on the walls with a degree of awe, appreciation for what they've been through. They're probably looking down at me with either bemusement or amazement. Each of them has a special story to tell, not only personally, but with the institution of the court. You look up at Marshall and appreciate the importance for him of having the court function as a court, moving the court from a situation where each justice wrote his own opinion and instead saying, no, we're going to have an opinion of the court, which was vital in establishing the court in its present form. Right next to Roger Taney, the most unfortunate of my predecessors, the author of the Dred Scott decision. And you understand that he saw this great problem in the country of slavery and he was going to solve it. And this is how he was going to solve it, and tremendously misguided and injured the court for generations to come. So that helps inform how you look at your own job. You walk down a little further and you see Morrison Waite. You had 1,000 lawyers and law professors and said, who is Morrison Waite? Not one of them would, well, maybe a couple of them would know. And that's a good lesson in, the job doesn't give you a prominent role or historical significance just because you hold the job. You look at Melville Fuller and you understand his role in making sure the court functioned collegially. You go in the next room and you see Charles Evans Hughes and you recall his vital role in turning back the court-packing plan. And you think about the importance of the independence of the judiciary, things like that. From time to time, I find it a useful reminder of the role of the court and the role of the Chief Justice.
As time moves forward, this building will remain timeless, and the work of its institution inside will still be tied to past precedent and tradition. But in many other ways, it is a forever changing place, defined by the human beings serving there as justices, all trying to interpret a document over 200 years old in the context of an ever-changing world.
You really can't judge judges unless you know the materials that they're working with. You can't say, oh, this is a good decision and this was a good court simply because you like the result. It seems to you that the person who deserved to win won. That's not the business judges are in.
We don't get it right all the time. This is a human institution and it has the same susceptibility to error than any other human institution has.
We have 300 million people. Probably have 900 million points of view. I mean, people in this country don't agree about a lot of things. And despite enormous disagreement, they've decided to resolve their differences under law.
What I do get a fulfillment from is living up to the oath to do it the right way and to know that on behalf of my fellow citizens, I've tried to be faithful to their Constitution, to our Constitution.
What I see, I think, has been very inspiring because I think you have 9 people who are working really hard and who are trying the best that they're able to do something really important in this country.
I think the most important thing for the public to understand is that we're not a political branch of government. They don't elect us. If they don't like what we're doing, It's more or less just too bad, other than impeachment, which has never happened, or conviction on impeachment has never happened with the court. So they need to understand when we reach a decision, it's based on the law and not a policy preference.
We have the Constitution and the laws, and I think they mean something. They don't necessarily mean what I want them to mean in every instance. They mean something, and I think the people of the United States trust us to interpret and apply those laws fairly and even-handedly and objectively, and that's the great responsibility that we have.
The Supreme Court, in general, has been respected by the American people. I think it's been one of the institutions of government that is most respected. So it isn't size that makes the grandeur or the specialness of the place. It's what it symbolizes and what goes on here that makes it special, and it is.